Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. I'm your host, Brendan Lupetin, and today we have a truly fascinating episode lined up. If you've ever wondered how cutting-edge data analysis can help trial lawyers like yourself secure better verdicts and settlements, you're in for a treat. Joining me today are John and Alicia Campbell of Campbell Law, trailblazers in the world of big data for plaintiff lawyers. The Campbells have spent years perfecting data-driven strategies to help attorneys maximize case value, refine trial presentations, and better understand how juries think. I've had the privilege of working with them personally on a study or two, and the accuracy of their findings was nothing short of stunning. In this episode, we'll cover a lot of ground, I hope. We'll start with a brief look at the origins of big data, what it is, and how it has evolved over time. Then we'll dive into how John and Alicia are applying this powerful tool to level the playing field for plaintiffs. We'll discuss the innovative products they offer, the current state of big data in trial strategy, and what the future holds for data-driven case evaluation. And if we have time, and I sure hope we do, we'll tap into some of the universal truths they've uncovered after running countless studies. And one more thing. John and Alicia, along with attorney Sean Claggett, have co-authored an essential book called Jury Ball, which I would highly recommend you pick up and read about how big data works and what they've been up to. It's really the deep dive about how this all works in much more detail than we can possibly cover in a single episode. So check that book out. And whether you're a trial lawyer looking for an edge or just curious about how data is revolutionizing the courtroom, you won't want to miss this conversation. So let's get to it. All right, John and Alicia Campbell, welcome to the show. Thank you so much for joining me today, because I know you guys are insanely busy these days with what we're going to talk about. So thanks for joining me today.
Hey, thanks for having us.
Good to see you. It's good to see you, Brendan.
Good to see both of you. And as I mentioned in the in my intro, the Jury Ball book is just awesome. And I remember when I think John on another podcast a while ago first mentioned it, I immediately was like emailing you like, hey, wait, where do you find the book? I can't find the book. He's like, well, it's actually not done publishing yet, but it is now. And for anybody out there who hasn't read it, we'll put a link to where you can find it. And I highly recommend it because it really is awesome. And I can't tell you how pleasantly I was surprised when I'm reading that book and my name popped up in the middle of it about, my case from a few years ago. I showed that to my kids and they were thoroughly unimpressed, but I was bowled over. So thank you for that.
Well, Brendan, since you mentioned that, I know we're jumping right in, but I'm going to tell you that your case to this day is still, I think, one of the top 5 most sort of accurate predictions about verdict, but also was the one that made us the most nervous because you were trying a med mal case in a conservative county in the heat of COVID with a place that you can't directly sample, right? Yeah. Like it was all the variables that make predicting verdicts hard. And it was also at a time where we were actually saying to people, Trump jurors are good in med mal cases because they were sort of opposed to the medical establishment and liberals were, clapping for doctors during the pandemic, right? And so I will just tell you, it stands out in my mind. One of the reasons it wound up in the book is because it stands out in my mind as one of the hardest predictors and one of the ones I was most nervous about when we sent it out the door.
Well, 2 things about that study and that trial that stick out to me, and I don't know if I shared the one with you, but to that idea that in the study, it was indicating, and you guys were touting at the time, sort of unconventionally, that, Trump supporters, kind of hardline conservative types might actually be good jurors in these rural med mal cases. So when we picked the jury, predictably, there was also a cross section where, the more liberal leaning people were going to be halfway decent as well. And just because that's the way that I'm wired, I was still kind of like, nah, I just, if I can find, liberal people, that's what I'm getting. And so I remember we got a good jury. I think we wanted mostly women. We got mostly women. And there was one guy who was wearing Birkenstocks with like wool socks. And I was looking on his online stuff and he was super into the symphony. I'm like, oh, this guy is going to be super liberal leaning. He'll be good. I want him. And so we get the whole jury. He's on there. The jury looks great. However, the 13th juror is in line with what you guys had told me would be potentially a good juror. But still in my mind, he was terrifying. He was, he had the Punisher mask. He didn't want to be wearing it. He had really hardcore anti-Biden, pro-Trump stuff on his social media. He was probably a 30-something-year-old guy. I was like, this guy, I don't know why. He just scares the hell out of me. So we try the case. And on the first day, the jury comes back and we find the judge pulls us in and says, hey, there's been a problem. What is it? Juror 10 is in the ER right now. And we get her on the phone and I still will never understand this. She jumped in a hole and she snapped her leg and she was not going to be able to make it. And she's crying. I'm so sorry. I feel like I'm letting you all down and everything. So she's off and in comes Punisher guy. And I'm just like, dear God. But I'm like, well, we only need 10 out of 12. So anyway, so fast forward to the end, we get this great verdict that was, wickedly on point with the study. And here, maybe 4 days after the case, who do I get a phone call from? The Punisher man. And he called and was really interested about the whole thing. And his main question was, did you think that verdict was fair? And I said, well, look, jury of 12 people came together and I got to respect that. It was great, and I think I maybe even mentioned your study and so on and so forth. And he said, well, I want you to know that I didn't think it was fair. And I was pushing for a verdict much, much higher than that for what happened in that case. He's like, but I got huge pushback, in particular from Birkenstock guy, that to award more money would potentially bankrupt the hospital. He's like, and I'm back there thinking that has nothing to do with what we should be talking about, and so on and so forth, which blew my mind that dynamic and just, rang further true. And then the second point just being, when we get the verdict and, it's line by line by line of the life care plan numbers, and I'm adding them up on a calculator, and it's steadily trending to the number that you guys had predicted in the study of, 10.8 and almost hits it exactly on the nose. Still, kind of makes the hair stand up on the back of my neck thinking about. So, and that's why I've touted your services at so many different CLEs for so long. But anyway, sorry to start the show off with that. But
no, that's a cool story. That's like my new favorite story because we'll get into how you do it. But I mean, I think the beauty of data, Alicia and I were talking about this yesterday, but for our kids' basketball team, is that data doesn't lie, right? As long as you do it right, it doesn't lie. And if you're willing to listen to it, it might tell you counterintuitive things. And so like in your case, the idea that a liberal could be bad on value and a Trump supporter could be good is not anything any of us were taught as plaintiffs' lawyers growing up. And frankly, it's not so true now. But it was really true during the pandemic when Trump supporters were literally out protesting against doctors in the medical establishment, and liberals were literally clapping and applauding doctors, right? And so we saw this moment in time where the data told us something that we would have never guessed. And the only reason we knew it was because we had really good numbers that didn't lie to us that could help us see it, because we wouldn't have seen it either, right? And to me, that's, people say sometimes they'll say well, John, you're an expert at this. Tell me what you think. And I'm like, I'm not an expert at anything except asking good questions and getting really good feedback from a good, clean sample of people and dealing with that data correctly. We might gain some instincts over having studied a lot of cases. Alicia and I were talking, I think it's like 850 civil cases we've studied.
No, right? I think it's like 900.
Maybe it's 900 now.
I think it's 900.
But we still find counterintuitive things in the data all the time. And then the hardest part is trusting that those are real when they go against our human instincts or biases or past experiences.
Well, I use your trial a lot, Brendan, because one thing it opened my eyes to was that you can have culturally something that is large enough that means we need to be asking more than just generalized. I mean, because we have general voir dire questions we ask, and then we have specific questions that we ask depending on the type of the case that you have that we found over time are pretty predictive for either med mal cases or pedestrian cases or motorcycle cases. But what it also makes me think is when you have something like Louis, for example, and the shooting of a United CEO, your case often makes me think now in the med mal context, hey, there's some questions I need to be asking about this because it's in the forefront, it's on social media, people are talking about it. And what we learned from your study is that when you have something culturally large enough that's causing discussion or disagreements, it does affect the way that jurors see a particular case in that moment in time. So that if you have a case coming up, yeah, maybe with med mal cases, you should find out, does Louis matter? And if a person tells you, yeah, I don't have a problem with, corporations have terrible greed. And if that's what it takes, that's what it takes. So it's very interesting. It really made me expand on the type of questions I ask for voir dire purposes for lawyers, depending on what's, in the air.
Let me pivot back to, kind of the start of, John touched on and you just kind of jumped off on there, Alicia. And one thing that I'm, always concerned with, in these studies is the, reliability, like trusting in it afterward. And the starting point that I'm always concerned about is that concept of garbage in, garbage out, and how, what do you do or focus on to help lawyers ensure that they're not polluting, the data so that what they're getting on the back end is reliable?
Well, we do a lot. It's probably our most important gatekeeping function. So, lots of lawyers, at least that send me presentations, either like to be neutral and not super argumentative. And when I get that feel from the plaintiff case, then when I go to the defense case, I make sure that the feeling is the same. Just like if a plaintiff comes in super robust and argumentative, then you're going to get feedback from me if your defense case is not equal to that. So we try to make sure that the presentation tone, whatever kind of, at least on my end, if the plaintiff comes out in a certain tone, then I'm going to make sure that that tone is equal in the defense case, along with just pushing people to say, hey, look, I know you hate this corporation, but the defense attorney doesn't. So go to the website, find all the ways that they are contributing to society and put up their logo and let's humanize them a little bit. And so I know that we try to do as much of that as possible, in addition to making sure both are similar links. And then there's just some things that we have learned over time in doing so many of these that stand out as important, ways of making sure that lawyers are not saying things like, and of course, the defendant is going to argue in the defense's own case because they can't even write it without it just being so stupid. So sometimes we're actually just filling in, we're taking that section and going, I have to rewrite this. This cannot work as is. So we do a lot. It's probably some of the most heavy lifting things that we do in terms of getting a study ready is trying to ensure as much as possible that it's not uneven. So that we don't because I don't want to run a study where I'm like, I don't know if this fact matters because it's not something that was as neutral as it needed to be. Or, if you don't give me facts, I can't fix that part. But the facts that you give me, the statements that you give me, I can fix to make sure that they're coming in similarly.
By the way, I thought it might be useful. Sorry, but as I was listening to this, I realized somebody who has never heard what this is I'll just say, the simple steps of big data studies are to put together a plaintiff and defense presentation that's shown to jurors online. Those jurors are vetted in lots of ways to make sure they're real people, paying real attention, giving real answers. And then you can get responses from hundreds or thousands of people on the case. And that lets us avoid some of the small sample errors and the things you get wrong when you have really small samples. And so what we're talking about now, right, is how do we put together those presentations that jurors are going to see to make sure that our jurors, our mock jurors, don't guess it's a plaintiff study. And we measure that. So one of the things I'll tell you is we ask people, who do you think sponsored this study? The plaintiff, the defense, both sides, an academic institution, a mediator, a court, I can't tell. And what we're looking for there is basically any answer is valid besides plaintiff. And we want at least 3/4, and ideally we want 80% of the jurors to guess somebody besides the plaintiff, because then we know we didn't tip our hand in the study as to who ran this. And that's one of the quality checks. The other, like Alicia said, all the things of all the way down to language. So for example, defendants do not call the plaintiff Brian. They call him Mr. Smith. And if in the plaintiff's case, you start referring to, well, when Brian was hurt, people think, well, that's weird. You know, if the defense case has no video, but the plaintiff's case has 5, you're overweighting it. We also just, over a period of time, you start to recognize that defendants tend to defend cases in certain ways. And so if we don't see in a TBI case, an MTBI case, if we don't see any defense argument about, hey, you can't see it on the scans, this is all subjective. By the way, it's mostly experts from out of town who've diagnosed it. If we don't see common defense tactics, we're going to flag them and say, do these exist in your case? Are you sure? Because they probably will, and try to build it out. And the goal then is that ultimately what our jurors see is something that to them is like jurors experiencing a real case. Both sides put on evidence. Both sides gave it their best try. Both sides had fair shots. And then we can get data we can trust.
On that point, one thing I think I struggle with, and I go back to my introduction into my own DIY focus groups was, I think, David Ball's book from 1,000 years ago on, how to do your own focus groups. And if I remember correctly, whether it was him or it was, other trial lawyers who've talked a lot about focus groups over the years, there was this suggestion that almost you should try to make the defense case, almost, if anything, like slanted towards the defense. And I worry about that. And I'd like to get your thoughts on that, because that could discourage you maybe from going to trial on a case that should go, or misunderstand what the true value of the case is. So, I mean, do you run into that sometimes where people are almost too Chicken Little-ish about what the defense is going to be and that sort of thing?
Yes.
Yeah, we do. I will tell you, we don't believe that, right? So what you just said that you should and I'm not saying you said it, but what was a conventional wisdom slanted to the defense? We don't really believe. What we tell people is you should put on your plaintiff's case full-throated, and you should put on the defense case full-throated, and we'll help you. Because that's the simple rule of all studies, and not just what we do, but in the academic world, in the economics and social sciences, the stimulus should be as close, the case presentation should be as close to reality as possible, because that's the best way to get measures of what's most likely to happen. So the minute you start saying, well, I'm going to hold back one of my great facts as a plaintiff, and I'm going to give the defense 2 things I know they won't get into evidence. Like you said, now we're not studying the real case, we're studying a hypothetical case. We're also making assumptions about what matters before we have data.
That's right.
And then we're getting a result, and I scare the shit out of somebody by saying your win rate's 50%, but that's because they kept out their 3 best pieces of evidence and gave the defense 2 things they'll never get in. That's not useful.
Or even if they have a case that's pretty good overall, when the defense case is at its best, the thing is I get on calls. Okay, so then what happens if I put in this piece of evidence that deals with this issue? And it's like, well, I mean, I don't know. I mean, I assume it will help, but we're all making an assumption now because it wasn't in there. And that might be something that jurors buy, but it might not be something jurors buy. And since we left it out, it's hard for me to give you information about it.
Alicia raises a good point. I was thinking about that too. The cool thing about big data or big empirical studies is there's also a solution to this. So if you call us tomorrow and say, I've got this case and it's 50-50 on whether or not I'll get in the OSIs, the other similar incidents of what the defendant did that was so bad, and this is why it was obvious they knew this product was defective or whatever. If it's truly 50-50 whether they'll come in, we can also run the study where some jurors see those OSIs And then other jurors see the exact same case presentation, but don't. And in doing that, we can value the case if they come in and if the court excludes them. And then you're prepared for your best day and your worst day. Or you could imagine it can be with anything. Hey, my client has an alcohol problem. I think I'll keep it out, but it might leak in. And if it does, great. Well, let's run a version with it in and a version with it out. And let's have data on both. And since we have really big samples, if that changes the value by 20% when we manipulate that variable, then it really does change it by 20%. And that's nice to know when you're talking about settlement or talking to your client. So we can also often test 3, 4, 5 versions of the case, ranging from a dream day to scary as hell day. And then we can know what those look like. And then the attorney is prepared for those different contingencies when they get sorted through motions in limine or motion practice or during trial when the judge finally makes a call.
Well, and I'm just going to segue off of that because one of the ones that people should put on their radar that I tend to ask about, especially when I think the defense that they're telling me is going to come in as absurd, is admitting liability. So if you have a hunch or you suspect they haven't done it yet, but they might, that is definitely one variable we should test because it will definitely change the outcome. In most cases, the damages typically go down when a defendant seems somewhat reticent to fight, and there are ways to deal with that, especially if you've got laws that start, managing the type of things that are coming in and what you're really holding on to for damages. There's some hot facts that if they admit won't exist in that case. It's another thing to kind of keep on your forefront. It's a standard question that I ask whenever I listen to cases from lawyers is like, is there a chance they're going to admit? Do you need to think about that a little bit? Could it be realistic? Maybe you make a little phone call, just chat up the defense attorney if you're not sure, because running it that way is very important because the picture can be very, very different once they admit liability.
I've had an insight, and maybe you can confirm or disabuse me of this regarding admitted liability cases, because I think the typical take is, oh, that's bad for us because we've got good liability cases and now they're cutting legs out. And it's making us look like we're greedy, that kind of thing. But I have felt, again, if you frame it the right way, that it's actually helpful for us because of this theory of mine. So I think that a lot of jurors, when they hear typical negligence cases, that term negligence, they oftentimes associate it with like criminal negligence, or they think the burden of what that is much higher than it actually is. We're always trying to say it's just like they weren't as careful as they should have been. People are like, no, did they mean to do it? This kind of stuff. And so that makes it more difficult than it should be for us to prove negligence. But if you flip it, they've now admitted it. And I can say, this is so bad. It's already been decided that they were negligent and 100% responsible. I have not tested this, but I suspect that a lot of those jurors are thinking, whoa, like they're negligent. Like they've already been determined negligent. Like this must have been pretty bad, whatever happened here. And I don't know if you've seen that borne out or not, but that's just my anecdotal theory on that.
I'll give you at least my 2 cents on that. I think it's very case dependent. And so let me give you 2 examples. We're working on a case right now where an 18-wheeler fell off a bridge, an overpass, and landed on the car below and killed the person. They're likely to admit liability. And if they do, there's a chance that the jury won't learn anything about why the driver did that. But the accident photos are horrific, and the behavior is egregious no matter how it occurred, because 18-wheelers aren't supposed to go off bridges, and it wasn't icy or anything else, and it was daytime, right? So in a case like that, I think you're right, because what jurors are going to often do is say, well, I assume cell phone, asleep, drinking, something bad, and I can tell that it had terrible, horrific consequences, both in the photos and in the fact that someone's catastrophically hurt or dead. And in those cases, sometimes admitting liability doesn't take the heat out of the case because the jurors still sense that something went very wrong and they're appropriately upset by how bad this is. Now, compare that to a case where a drunk driver hits someone from behind at 20 miles per hour. The damage isn't really bad. And we're dealing with a mild traumatic brain injury. In that case, the jurors learning that the driver was drunk and had previous incidents and was driving on a suspended license is a lot of help to the jurors sort of not just talking all the time about the MTBI. And the only thing they do is deliberate. Are they really hurt? Did you hear the before and after witness? What did the experts say? Did you receive the DTI? I don't know if that's bad. They'll talk about the bad behavior. And if the defendant admits it away, it will likely reduce value. Right. And so what's interesting is one of the drivers in whether admitted liability reduces value has to do with whether or not it effectively removes anger or heat from the case. And I think generally, if we had to plot a trend, admitting liability reduces value some. In some cases, it does almost nothing. And in some cases, it does a lot.
Well, it also depends on how hollow it seems that the admission is too. So sometimes there's some real angles for a plaintiff's attorney to get at the admitting of liability, where they're like, hey, can you take that seriously? Or is this just more of a profit motive here? Like, depending on your case facts. So we've also seen it where admitting liability is what the defense is going to do, but the way that they're going to go about it just to lessen the damages, if that's called out to jurors, then they're like, oh, well, that's just, shit.
For example, when allowed,
it doesn't have such an effect because it actually operates as a heat driver, as an anger driver.
I was going to say, I agree 100%. At least it's a great idea because when allowed, we've had attorneys who go in and say, hey, they admitted liability last month. This case has been on file for 4 years. Let me show you. Sometimes let me show you all the stuff we've gone through. And then right before they got in front of you, they admitted. And if a court will allow the timing, all of a sudden that admission looks really different. Right. And so, I mean, I think it is, it's very context specific, and you'll hear us say this all the time. But one of the things we found about cases, each one genuinely is a world unto itself, ranging from whether admissions of liability help or hurt, to whether the crash photos benefit you or not, to whether you need the before and after witnesses, to whether the experts play, to which jurors to seat. No two cases are quite alike. And so, the good news is that is knowable through a combination of gathering data through focus groups and big data and small data and experience. But it would be a big mistake, I think, and I think a lot of attorneys, because it's comforting, sort of look for a general rule for a lot of things. And unfortunately, there are very few general rules in trial practice. We've only seen a few real universal truths bear out. Most of the time we're saying, hey, we got to look at this case to sort this.
Yeah, absolutely. On a kind of a related note, when attorneys are preparing their fact patterns for you to consider and then ultimately to be presented, to the participants that are going to evaluate them, do you feel that it's, and again, I'm guessing the answer is going to be, it depends on the case, but, most cases are driven by big picture issues like a delay, a lack of urgency, rather than these super nitty gritty granular issues. But sometimes it seems like the attorneys, I know myself, I still want to get all those little nitty gritty pieces. Well, the surgeon said this, but this person, and all these little tiny pieces. Do you have a recommendation to people, or again, does it just kind of depend on what you're seeing in the fact pattern on how you approach that? Should it be more general concepts or granular?
I mean,
I stumped you.
Well, no, I tell lawyers to write. I tell lawyers to write the way that they're going to present their case because I don't want to inhibit anyone. Does that mean that sometimes I get exceptionally long presentations? Yes, it does. Does it mean that sometimes there's a lot of information included that jurors do not care about? Yes, that's true. But if it makes a lawyer feel better to include it because they think they should, then all it does is make me typically include in the study whether or not some of those nitty-gritty details actually matter. So when we ask evidence questions and we have jurors rank strength of evidence, whether it helps the plaintiff, whether it helps the defendant, or it's a neutral fact, I just make sure that a lot of those nitty-gritty details are in there so that at least you can know, I like this detail and think it's important, but maybe jurors don't, or it doesn't land the way you think it does, or it's often neutral and really too nitty gritty for jurors to care. Because jurors typically, I mean, there are times where nitty gritty details matter, but that's, yes, case specific, right?
I would say
Some details do matter more depending on what you're alleging.
Yeah.
And how the plaintiff seems or comes across.
I will say this, though, as a general rule for my 2 cents is I agree. Like I tend to leave them in too, because who knows, right? But I will tell you that I think there's pretty good evidence at this point that jurors decide cases on the big plate tectonic sort of stuff and not in the weeds. And I'll give you 2 sort of proofs. One is that you're seeing a lot of big verdicts out of speed trials and trials that are tried. I mean, Alicia, I'll brag on her. She's my wife, and my partner, but I also just brag on her. And they just went and tried a very hard excessive force case. She, Javad Kasali, and Jim Wersch, and several others,
Jack Waldron,
and others, tried a case in a conservative court in the Eastern District of Missouri, federal court. It was a case with a lot of physical evidence, with 6 or 7 different police officers, with an animation, and it was a death case where a white officer shot a black person in the back. They put on the plaintiff's case in 3 days, and they got a $18.75 million verdict in that case. They didn't get in the weeds, right? They found their key issues and they hammered them, and they stuck to them so that the jurors could not miss them and would discuss them. And I will also tell you that we have found over time that we predict verdicts more accurately with shorter presentations than with long ones, which tells me something about what's moving jurors. If we can, in a 6,000 word presentation that takes people an hour or 2 to work through, predict the result of a week or 2 week trial within 10 or 20%, then by definition, it can't be all the little things because we didn't include them. And so that's my long way of saying, I think we often, because we live with the file, get really invested in the details. And it's good to, through a number of ways, to get feedback from people, including small and big data, to sort of get back to what are people actually taking away from this case, and what are they actually talking about when they have to decide it. And, I'll give Mark Mandel a shout out because, Mark talks about the just can't get over issues. And I think he was onto something, right? Find the 2 or 3 things that plaintiff jurors, once they get it, come your way. And find the couple of things that always lose you defense jurors. And deal with those. And deal with them effectively. And spend a little less time on, but the expert said that he was licensed in Maryland. But really, his license expired 2 years ago. Because I don't think anybody's won a case on that.
But it's interesting that you say that, though, because sometimes the nitty-gritty details that people think as nitty-gritty details are big deals. So, like, when I'm talking to somebody, I'm like, oh, okay, so your client fell. How old's your client? Which seems like a nitty-gritty detail. But to jurors, if you tell me that person's 75, they're starting to go, 75-year-old falls. Or if they're heavy, then suddenly I'm saying, okay, is your client a little heavy? Because that seems like a nitty-gritty detail sometimes, but in certain cases, that's a huge deal. It's a huge deal. So a lot of times I'm spending time asking too, because we've just seen enough cases and I'm like, in that kind of case, some of these indicators are going to matter quite a bit, even if they're maybe not, because we know our clients, we deal with our clients, love our clients. So I don't always think of them the way that jurors who just get this first impression in dealing with a dispute and your client and the way they see them and what matters.
Well, I think that might be the distinction, is that because I think impression is such a huge factor by which juries judge circumstances. I know in premises cases, I think it is so critical to find ways to show whatever you can do to show that your client is a very detail-oriented person, finding ways in their job or hobbies or having other people testify that they're anal, they pay attention, that kind of stuff. Even though you're getting into this kind of minutia, I also think it's always important, if it's the case, to try to squeeze in a question that they've never filed a lawsuit in their entire life before. You know what I mean? Because people are kind of wondering that, and you answer that question. Okay, they've never done this before. So this isn't one of these people that's coming in looking to, fake a slip and fall to get this kind of stuff. But so I think the balance maybe on the nitty grittiness is big issues, but, impression, whether it's on the defense, the plaintiff, the overall aspect of it is still big picture issues that you gotta not ignore.
Yeah.
Yes.
So let's pivot to, the current, the current offerings of, it's Campbell Law now. And I have to say, empirical jury was way easier for me in an empirical jury. And I understand why it's Campbell Law now, but tell me about the different big data offerings that are out there for trial lawyers to use to get better verdicts and settlements.
Well, so big data would be with John and I, where you go through that regular process. I think our newest offering is what we call Fred, who is big data's little brother. That's what we say he is. And he is small data, really. And so it's an online platform that allows you to build your own study. You still have to create a presentation like you do for big data. It needs to be much shorter. But once you have access to Fred, what you're able to do is go in and basically create the study with our guidance. We've already written, I think, 65 jury instructions. So it's a drop-down menu. So if you have a bread and butter negligence case, it's really easy. You click through, have your presentation, upload it, come up with pieces of evidence you want jurors to rate, write a couple of custom open-ended questions, pay for the study, and 3 to 5 business days later, you have the results of what 75 people in America think of your case. The reason why we offer that is for what John mentioned earlier, which is, there's a lot of people who have big cases, and they also have in their office many times smaller cases that don't justify the big data cost. But with Fred, it's a much more reasonably priced item for cases that have like $1 million of coverage or less. We tend to say, hey, that's a good range for running a Fred study. And getting, what is the equivalent of 5 15-person focus groups. You just get in one shot. So, and we'll tell you anything from, we can allocate fault in Fred. We can run punitive damages in Fred. We can get injury severity ratings. And we also ask about case credibility of these jurors. So the metrics that we have in big data to make sure people are who they say they are, that they're paying attention, comprehending, are still there. It's just that we limit how long a presentation can be, and then we just limit how many jurors participate, and that's what helps the price go down to about $7,500. Now we can't run and do the fine, tuning of data. We can't run variables in and out, but a case $1 million or less in value is not really. It just doesn't really work.
Yeah, for the full studies. Yeah, totally get that. Yeah. On the big studies, and because I have a lot of people come and ask me, hey, I have this case. Do you think it's worth me going and doing a big data study? And, of course, I'm like, well, it kind of depends on the facts and a bunch of different things. But what should attorneys who are kind of, should I pull the trigger on a full-blown big data study? What should they be considering regarding like what it's going to provide them? Meaning, is it a, the silver bullet for how they're going to win the case? Is it just an analysis for settlement discussions? Is it, what are the nuances? And I know that's a very big question, but for people thinking like, is it worth it? Should I do it? There is tons of coverage potentially. Upside is potentially huge, but what are you telling them?
Well, let me give you maybe an example and an answer, because I think it can do all the things you just said, and it depends on the case. So for example, we just ran a case that I won't go into details about because it's live, but I'll just say we ran a case that has really good counsel on it, has really good damages, and I think they viewed it as a case with a lot of value. It may still have it, but I will tell you that when we ran it, it had a win rate of 35%, meaning 35 out of every 100 jurors voted for it. Well, that's abysmal. We've never had a plaintiff's verdict with numbers like that, like literally ever. In that situation, those people paid quite a bit of money to get a report that said your case is really, really, really hard to win. Kind of bad. Maybe we'd call it a dog. Well, okay. Was that worth doing? Well, hell yeah, because they believed that they should go try it and turn down massive offers because they had such a big injury that they're just going to charge in and try this 3-week case, spend $250,000 in trial costs. And the most likely result was they're going to go home with zero and their client's going to be really mad. Right? So in that situation, we didn't send good news, but we probably sent really valuable news. right? Even if maybe when you first open it, you're not thrilled. There are other cases where they were going to win it whether they talk to us or not because they worked it up right. It's a dead bang good case. Sean Claggett's case comes to mind out in New Mexico, like where by the time they got to trial, they had a spoliation instruction and instruction on liability because they had beat the crap out of the defendant in discovery and in litigation and in motion practice. They were going to win. What was the defense response in that case? Their response was, this is a single injury case in one of the poorest counties in the United States. And yeah, you're going to kick our butt, but if you get $15 million, you ring the bell. Well, in that situation, what data let us know was poor, rural jurors from New Mexico and places like that of any race, color, creed, the low-value jurors gave $50 million. And so $15 million, although it sounds like a lot of money, was a dramatic undervaluation of that case on its bad day. And so Sean and his team had some confidence to say, that sounds like a lot of money, but it's not, and try the case. And the verdict was $485 million. And in that situation, I think data helped. Sean's already gutsy, but it helped have confidence, including with the guardian ad litem, to say, hey, this is not a good value for this case, even though it sounds like a big number. And then the last I'll give, and then I'll shut up, is we also have cases we study, often med mal cases, where in product liability cases, where the win rate is 60%. 6 out of 10 vote for the plaintiff. But in the jury analytics, in who are good and bad jurors because they carry too much bias or not, there are people that vote for that case 3 out of 4 times, and there are people who vote for it 1 out of 2. And there are issues that, when focused on, help people understand the case better and be more likely to vote for the plaintiff. And in that case, what the big data study might have done is help you move from a 60% win rate to a 70 or 75% win rate, which in deliberation, having 1 or 2 more jurors can sometimes be enough to mean it swings your way. And so, data doesn't always say you win. It doesn't always help you win. It doesn't always increase the value. It does those things differently in different cases. But what I will say is, without it, you are guessing. And there's no other way to say it. You are guessing on your case's value. You're guessing on whether it's good or bad. You're guessing on how much to ask for. You're guessing on which jurors are good for you. And candidly, this is self-serving because I do this work, but I don't care. You can go to somebody else. I don't think there's much excuse for guessing anymore because it is possible to know. And our clients who are working to go get their results and they have one case, I think if you asked them, would you like to have real information from what's most likely to occur and us make decisions based on that? Or would you like my gut? No matter how good the lawyer is, the answer should be your gut plus data, wherever you get it and however you get it.
So really, if you're people who I talk to, if you have a big enough injury, a life care plan, and coverage, significant coverage, that's, more than $1 million, really, then it's worth running the data on because you don't know where you're leaking money. You don't know where you're leaking jurors otherwise. So typically people that I talk to are saying, hey, I'm calling you. I've never done data before, but I have enough coverage on this case. And I think my injury means that I should probably get most of that coverage, but I'm not sure. So I have some room with expenses. I think I should take a run at data. And really that's the two kind of ways of thinking about it, or at least how I do now. If it's $1 million or less, you should probably use Fred. If it's more and you've got significant damages to your client, then you probably should run big data on it and just know.
Yeah, I'll just say last thing. One, if you do it, if you think numbers wise too, sometimes people ask us and I say, well, look, if your case is worth, let's say $2 million, and the only thing we could do for you is increase the value by 20% because we can help you pick a better jury and help you get the right damage ask. That's all we can do. Well, then that's $400,000 in value, and big data doesn't cost anything like $400,000, right? So if we think of this as sort of cost return, our view is, and I will just say, I feel like I'm selling. I don't want to. So I'll just tell you, we practice what we preach. We have our own cases. We work on our own cases. We have our own files. In our office, cases do not get selected, worked up in discovery, or tried without small data and big data studies, because we cannot make good decisions that we feel comfortable with without the information.
Yeah. And I think there's so many Yeah, so many kind of hidden aspects and benefits to these studies that people don't think of initially. And maybe the biggest one is, and this cuts both ways, are cases of potentially significant value and educating your client. And educating your client regarding maybe they think their case is $1 billion case and it turns out to be a dog, or conversely, giving your clients the courage and belief that they should go to trial because what the defense is offering, if you compare it to the data, is woefully below. And there are so many instances, and it seems I'm sure most trial lawyers, certainly I know probably you two can sympathize, but when you got your great case, your client doesn't want to go to court and they want to take whatever's offered. And when you have your crappy case with all the problems, the client is totally emboldened. I was like, it always feels like you're, once in a blue moon that the stars align properly, you've got both going in the right direction. But I think, John or Alicia, you kind of mentioned this in the Jury Ball book. And to be fair, it's not, oftentimes for many of us, the big study is not economically practical. But, you kind of made a reference, John, that there's so much with this available. In some instances, it's almost malpractice or could be argued to be malpractice that you wouldn't do a full study, especially say in Sean's case. It's like the study shows the case is worth an exponentially higher amount than even this large amount of money that the defense is offering. And if you're not bringing that information and that is available to your client, you're arguably doing a disservice. But again, everything has to be kind of weighed,
Sure.
practically.
Yeah, I mean, look, I understand that people are like, hey, I've got cost in the case. I've got, I get it. But like in Sean's case, the crazy thing is, if we played that out in 100 alternate universes, it might settle 98% of the time for $15 million. And then what's crazy is the client would be happy. The attorney would dine out for the rest of their life on their $15 million verdict in the small county in New Mexico where the average income's 15 grand. And what nobody would know is that they significantly undervalued the case for their client. And like, look, we're all lawyers. They also significantly undervalued the case for themselves and their family, right? And they wouldn't know that because they didn't look. And so, it's interesting because the only thing I'll say is once you use data, it can be a bit addictive because you feel a little naked guessing after that. And so like Sean, I love it about Sean. I think he might believe in data more than I do. I mean, and more than Alicia does. Like Sean, it's real simple. Like now he says to people, hey, this is the average value of the case. I've studied it carefully. I've studied it more than once. If you want to pay me the average or something very close to it, because that means I don't have to wait years for it, cool. If you don't want me to pay me the average value, assuming my client will listen to me, I'm going to try the case, right? And for him, it's that simple. Because why would I settle cases for less than they're worth? But the flip side of that is if I ask attorneys, what do you think your case is worth? Or even if I guess myself, the number of times that we're right is very low. And so without having real people, right? I mean, we're talking about big data, but I mean, really, at its simplest form, we're saying get out of the attorney circles in your own gut and go get real people to look at real evidence and give real values. And then let's know what the range of likely recovery is and the most likely average. Then let's make some decisions. Now, for your client, yeah, I mean, look, sometimes that means you say to your client, I know you think it's worth $10 million. And sometimes it is. But 1 out of 3 times we try this case, you get $2 million. And I need you to know that. Maybe they'll listen to you. Maybe they'll be so hard-headed you go try it anyway. But I think for all of us thinking as lawyers, it'd be nice to have it in the file that we had a real value for the case and we told them. And on the flip side, it's a shame to think how many times a case probably gets settled for $3 or $4 or $5 million that was worth 10 or 15 or 20 because the defense kept saying, yeah, but this is a rural county and they don't give big verdicts and they're conservatives and blah, 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 blah. And eventually that got through and the case got settled for way less than it's worth, which means the client got less money, the attorney got less money, and the defendant who did something wrong got a discount.
Yep, 100%. Just because I want to be mindful of your time, and we've been going at this for about 47 minutes now. There's a couple really key issues I want to cover, and one is what you've already talked about, that your studies tell you the the win rate. And I understand that at least, and I don't know if it's based on just, what you see afterwards or if this is a statistical basis, but there are certain thresholds, say, above which you are almost a lock to win, even if it's not 100%, below which it's a coin flip, even though it's not 50-50, and below which you're almost never going to win, even if it's not zero. So can you walk us through that a little bit, how that works?
Sure. I mean, they're big buckets and the science is always evolving, right? So I'll say that, but I never like to sort of oversell the confidence. I mean, like there are things that are knowable and things that are still hard. But what I can tell you is, for example, we know that when we see win rates below 50%, what that means is, barring some intervention through selection or improving the case, the most likely result is that there will be more defense jurors than plaintiff jurors in the room. And we know both from looking back at verdicts and from lots of science on human decision-making and deliberation in lots of settings, that that's not good for the plaintiff, right? Because now it's easier to vote no than yes for lots of reasons, including effort. And if what has to happen is the minority needs to persuade the majority, we have to view that as highly unlikely. Right. And we've seen that play out as highly unlikely, which is why I think I'd have to go back and look at our charts. We track it. I think we have 2 verdicts below 50% ever for the plaintiff. It just doesn't happen much. And we have a number of defense verdicts where either because there was no offer or in one who I won't name names, a lawyer just didn't believe the data. They went and tried the case and lost. And in that case, they had a bunch of money on the table and they were like, no, I'll beat the numbers. And they did not. Between, and this is loose, but between 50 and 65%, we're starting to say on any given day, the jury could be even or the plaintiff could have a mild advantage. And what that tends to turn into is that the best the data can do right now is say, that's roughly a coin toss case. Because it could be as simple as when you go in back there and they take a straw poll, who speaks first or who speaks a little louder? And those are very hard, no matter how much data you have, to predict. Because it could literally be, did the person have lunch that day or not, that decided to speak up first and say, I'm for the defense. And that made everybody feel a little less certain about their plaintiff vote. And it was even. Above about 70%, we really like the plaintiff case. Now, we've had a couple losses there. It's not a guarantee. It's something like, we think it's something like 4 out of 5. Because it starts to tip heavily in the plaintiff's favor. But of course, that means there's 1 in 5 you lose. But we start to think the plaintiff on average is ahead, and ahead in a way that if the jury starts to discuss it, it's very clear to the defense jurors that they're radically outnumbered. Now, in some venues, you only need 9 out of 12 or 10 out of 12. You're almost there. And even in unanimous venues, the number of times that the 3, for example, in a jury of 12, the 3 will persuade the 9 is not 0, but it's a low number. And I think that's about as good as the science is right now, right? So we have never said anybody, except in an admitted liability case, you'll win. But we can say, playing the odds, what are the likelihood of winning? And this is a tired analogy, but for me, I think of it a little bit like if you play blackjack or cards. If you have a 20 down in blackjack, you are likely to win, and you're very likely to win. But nobody's surprised when they lose it every once in a while. And so the best we can do right now with big data, and I think in human decision-making generally, in economics and in everything else, and in marketing, is we can play the odds on what's most likely to occur and make good decisions. And over the course of a career as lawyers, that turns out better for us than if we didn't. It does not mean we won't take a bad beat, as anybody who's ever played cards knows.
Right. But I think human beings have a hard time. I'm 75%, and in their mind, it's 100, but it's not. It just means
Right.
that you have a very good chance, but not a perfect one of winning. On a related note, so somebody does a study with you, let's say it comes back 60%. Presumably, in addition to telling them that, this snapshot, this is what we're learning on your win rate, do you have, whether it's a rule of thumb or something, statistically based on sort of the uptick percentage that the value that they get, whether it's picking the jury, knowing the best demographics of who, or, not, I shouldn't say demographics, but the best type of qualities or belief systems in jurors that they're going to get, or maybe refined versions of what these are your best facts, these are the worst offenses, and how to blunt them. Do you find there's a kind of an assignable percentage uptick in the win rate?
Yes, I would say yes, with some caveats. But I would tell you that if you do it all right, we expect we can move the win rate by 10 or 15%. But I will also tell you that we don't expect we can move it by 30%. Sure.
No.
Right. And so often somebody will study a case and it has a 40% win rate. And they're like, yeah, but when I pick a good jury and I have to say, or Alicia has to say, listen, if you pick a good jury, your good jurors vote for you 55% of the time. And if you really crush the issues, you might get to 60%. But that's essentially a coin toss. So you went from you're really likely to lose to flip a coin, but there's no slam dunk here, right? The difference is, let's say you're at 65% and you're right on that bubble where we're saying it's almost a coin toss, but you're kind of ahead. In that moment, moving 10 or 15% can be a lot, right? And so I think that's the range we tend to see. And we have some experience with this because we often will have a study run, learn from it, and then meet with the attorney, and then we reframe it and work on doing what jurors are teaching us. And then we can ask, did that make a difference? Often it does, but it would be untrue to say it makes more than a 10 to 15% difference in most cases.
Makes sense. Let's talk for a minute, if you'll indulge me, on no-ask cases, no-ask states, which unfortunately I live in, and
you are in.
It's
yes.
painful to read. I can't even remember what chapter it is, but maybe it's multiple chapters about the importance of the ask and how that impacts the outcomes of the case. And us poor PA practitioners, have to just skip over that chapter pretty much. But what in cases that are significant, potentially non-economic damage cases, how do you go about studying? Or what advice do you have based off the studies that you've conducted for us practitioners who can't suggest a specific number to the jury for non-economics?
Well, I mean, we have an academic paper right now that we're working on writing about this because it is lousy and jurors are very frustrated with it. So we still get communications from jurors who take our studies who are always annoyed about the fact that there's no number to consider, because even though they may disagree with the number given by the attorney, they'd like to hear one because they don't live in these worlds of like, what is the loss of an arm worth? I mean, it's just so hard for them to value. So, and we know just from the data, people are very sensitive, and your credibility is closely linked to the damage requests that you're making in cases. Because if jurors, the conventional wisdom, if it's too much, you seem greedy. That's true. If you don't ask for enough, you can offend and turn off jurors because they don't understand how you're valuing the case. So in Pennsylvania, what I tell lawyers, specifically, we work with a lot of Pennsylvania attorneys, is like, we have to think very carefully about the vehicle with which we ask for damages. And the reason why is because we're going to have to do something to make up for the fact that there's no number coming out of our mouths. So typically what we have found is, for example, the man in the black suit as a vehicle for kind of demonstrating, hey, this is what this person's living with. We want you to hear it, see it, feel it through this narrative, because at the end, I'm not going to be able to say a number, but we want you to have some kind of feeling about it, that it should be large. And so I typically recommend that in states where you can't say things. I mean, it's harder, the wrongful death context is much harder. The man in the black suit doesn't work as well. But when you have an injury case, that's typically what we find to be most fruitful. When we run it with the man in the black suit and without it, lawyers do better with it in when they can't make a non-economic damage request.
I'll just quickly add to that we think of the holy trinity of non-economic damage approach as being acknowledged to jurors that this is incredibly difficult, because we know that most jurors rate this as the hardest part of their job.
Yes.
That's step one. Step two, acknowledge that money is insufficient to do what we'd really like to do, which is go back in time and prevent this, or wave a wand and heal this person, or bring the loved one back. Jurors need to hear those things, and the attorney who says those things is addressing them where they are, because they're frustrated with the task. The third typically is give them meaningful guidance. And that's the part you can't do in Pennsylvania, West Virginia, DC, New Jersey, some states. So then I think what Alicia's saying is exactly right. How do we give them some vehicle to think through and feel like they're not being left in the wilderness to sort of wander around for the number? Now, in case any legislator in Pennsylvania listens, or any of these states, I will tell you, there's already published literature, and we're researching it more now with academics at Cornell. The thing tort reformers are most upset by is the idea that juries could be all over the place on the same damage, that one jury could give $1 billion and one jury could give $9 and whatever. The number one way to guarantee that happens is to give them no guidance at all.
That's right.
Because then you'll have a juror say, I believe this is a severe injury. I believe the defendant is fully liable. And one juror will give $100 and one juror will give $1 billion. If you allow both sides, because by the way, it's not just the plaintiff getting guidance, right? If you allow the plaintiff and defense attorney to give guidance to the jury, then at least the jury has something to work from and to start to make that decision. And so the function of not giving a number is to create wild variability in awards by when jurors need guidance most, giving them none.
Yes.
So I'll just, that, but I just want to say it. It's academically sound. There are already published papers about it, and there will be more. It's not wise. Beyond that, while you live in that regime, I think you have to try to find some substitute. The only other thing I will say is, if there are numbers in the case, dollar amounts, that can help them think about the scale, they will be useful to jurors. So, for example, if a company spends $10 million a year on advertising and $100,000 a year on safety, and that is in the case, that will at least help jurors think about what some form of a number in a case, much more than, I just want to disabuse this idea for plaintiffs' attorneys, much more than the idea that if you say there are 66 million patios in the United States, and this was a patio they fell off of, and so 66 million patios, and they fell off this patio, and therefore 66 million patios, that somehow the jury will give $66 million. Look, the anchors like that work in a total vacuum, not in a complicated case where jurors are taking it seriously. And so giving anchors that are just random numbers that sound high doesn't manipulate juries. No court needs to worry about that. It doesn't. But I will tell plaintiffs' attorneys it also doesn't work, right? Yeah. So what we really need is to be able to give jurors guidance, and then it's a fair game because the plaintiff and defense can do that.
Yeah, I mean, even think as much about expert hourly rates. Like, even if what you're getting out is how much is the defense paying someone per hour to testify here or to be on this case? I mean, anything that you can do that gets out. I mean, because even if a juror takes that back and goes, well, this guy lost, how many hours of not working? Well, we know that this guy's making $850 an hour. I mean, you got to do whatever you can, because at the end, it's just.
Yeah, of course, the problem in Pennsylvania is you can't even suggest they should do that math, right? No, because you also can't make up the deal.
However, I'll give you a perfect example, Alicia. And who knows if this is what actually happened, but I tried a case several years ago, and the verdict came out to be $2.1 million. And the breakdown was $700,000 in past, $1.4 million in the future. And I had gotten from the defense medical examiner how much he makes in a given year. And then I extrapolated it out over 5 years. And what was the number? $1.4 million. And I showed that in closing on a slide with him and his different opinions. And then at the bottom had, and how much does he, stand to earn in the future from giving opinions just like this, 1.4. And I can't help but think that those numbers, because it was a straight non-economics case, there were no economics. So where did they get that number from? So that's an example. I will also point out that for anybody not familiar with the man in the black suit argument that Alicia was talking about, I'll do a short form episode where I break down how to do that, because I do believe that that's a very, very effective argument in our state. And again, anecdotally, I've had a couple of jurors in cases where we got non-economic verdicts talk to me afterwards and say that specifically helped them, that they were skeptical of why money for pain and suffering. But when they were presented that, there is no time machine, there's no magic wand, juxtaposed with, and so this is what we have. And then thinking of it in that format, they found it to be very effective. At least a couple of people did.
Yeah, Brendan, I'll tell you that we actually studied the man in the black suit in Pennsylvania, where we had run the study and not used it. And then we changed absolutely nothing, but used that. And we saw a 25% increase in the awards. And so, yeah, I think there's some data to say that whether or not you can ask for a number, I think it's a very useful vehicle. I think in a state where you can't ask for a number in the right cases, in catastrophic injury and death cases, it's essential.
So here's an interesting kind of related point to that issue. And that's fascinating that you now actually have evidence of its effectiveness. So in those cases, I have found sometimes hindsight, and Greg, my partner, has kind of told me, I'm sort of like I'm a tool, but I'm a hammer. You know what I mean? I kind of have like one speed, and I'm trying to get better over time, to be more nuanced. But every case, whatever the size of it, I'm doing the man in the black suit for a ton of money. Freaking dump truck of money comes in and this kind of stuff. And Greg wisely pointed out that in some cases, I probably have turned off jurors because even though I didn't say a specific number, I'm suggesting a really giant number, which then comes back to your studies of that ask can really impact things. And if I'm in there and I'm sort of suggesting to them on a case that, kind of a tough case, and, maybe they would give us a few $100,000, but I'm suggesting, it's an 8-figure case, people are like completely grossed out by me. So I think that the way that you probably make that argument too has to be very dependent. I'm almost wondering if there would be a sense in, while we couldn't do an ask for a specific number, if there would be value in higher, mid, lower, for purposes of how you present that argument in the end, staying credible, not underdoing it, not overdoing it kind of thing. So I don't know.
I will tell you that in our, just to briefly respond, one of the things we measure in our studies is we ask jurors, you gave an amount of money, but what did you mean for that to be? Did you mean for that to be small, medium, large, or very large award? Because, of course, somebody could give $1 million and think they're being austere. And somebody else could give $1 million and think they just gave you the most generous award ever. And so we wanted to see behind the numbers. We also asked people to rate injury severity. And they can rate it from not at all severe to incredibly severe on a 5 or 6 point scale. I'm a big fan, if you have those numbers, of using them to talk to jurors, because then you can say something like, hey, in this case, if we think of injury severity as not at all severe, somewhat severe, moderate, severe, very severe, the evidence is like, look, my client can walk and my client, right? So I wouldn't tell you it's very severe, but I would tell you it's moderate to severe. And I would tell you that moderate to severe requires a moderate to large award. Well, now what we know is we're mapping on with jurors to their injury severity and their desired award size. How they translate that to dollars without giving them a number, there will be some variability. But at least what we didn't do is what you just expressed a concern about, is to basically say, essentially, this is a very severe injury and you should give a very large award. And all of them are thinking, that's not how I feel.
Yeah.
Right? At least we can sync up with it.
To close out, can you, now having done 900 plus of these studies at this point and rolling, can you give me, maybe your top 2 or 3 sort of, universal rules of thumb, that you see over and over and over again, that, again, with the caveat, every case is different, the facts are dependent, but what are some kind of big picture topics that people can keep in mind from what you guys have learned from the studies?
Well, I can give 2 that have come up recently that I think are worth honing in on a little bit. You should always consider your plaintiff. And what I mean by that is jurors are super sensitive in lawsuits about who's taking. So if you have a death case, but it's perhaps a parent who hasn't been involved in a child's life for several years, people can be very offended by the death, but they are definitely staring at the plaintiff and where the money's going to go. And so it's very important that when you're taking on cases, you're considering all those types of things. Or if a child's coming from an abusive home, but now who's going to take his mom and dad who were abusers? It's amazing how many of those get filed, but it's a really hard fact to get past for jurors, because jurors do look at where the money's going to go. And so it will have a large effect on liability and your damages even.
And I'll just note when Alicia says that, the good news is sometimes there's a solution, right?
Sometimes.
Name a trustee, set up a charity. There are sometimes options, but you have to be aware of it to know it. And yeah, I completely agree. It's people often think, well, it's a bad injury and they won't care much about that.
Yeah, that's just not true. Just not true. And the second one is you should always, always, always look for independent witnesses in all aspects of your case. And what I mean by that is about your client's injury. Family members are good. Independent witnesses with nothing to gain are better. In the incident, people who are involved are good. But if you have anybody watching that's outside, that's always good. And 3, yes, police reports matter. So even if a police officer gets the situation wrong while they're there or writes it down in a report, that's going to matter, because jurors are looking for people with no skin in the game who are coming in and providing testimony about either damages or the incident, or they're going to look at all of that. And so it's a very hard thing. I've seen people lose cases because there was a police officer on site who misreported on, like body cam footage what happened, but jurors just couldn't get past it. And they're like, well, I mean, he was there. Why would he be wrong about this? Even though there seemed to be evidence he was. And likewise, I love John's case where a man had a TBI, and the best witness about his damages was his dry cleaner, because the dry cleaner came in and said, hey, before this accident, he came in and gave me stock tips and was with it. And now I help him count his change. So independent witnesses are very powerful.
I'll just say a guy like that, a dry cleaner witness, is worth 3 family members, 4 experts,
For sure.
right? Truly. But why don't we look for them more often? Because it's easier to control experts we pay, family members that we indirectly know, and our client who we represent.
That's right.
So the extra work to find people who don't have skin in the game as before, after witnesses in cases and in other situations is essential. I completely agree. The last one I'll say is, this is my rule: credibility is king, and it's a currency that runs through the whole case. And that might sound obvious, but you can leak credibility in a lot of places. So there are people who go out and get the biggest life care plan they can figure out because they figure, well, the juror will discount it anyway. So I'm just going to go get the $80 million life care plan with all the inflation. But then the defense starts to pick at the stupidity in that life care plan, and your credibility falls. And then you make the lost wages claim. And you say, my client can never work again, but they're 25 and yeah, they have a bad foot now. But actually, a lot of people with bad feet work. Yeah. Right. And so the juror says, what the hell? Why didn't you model part-time work or lower wage work or non-physical work? And your credibility comes down. And that credibility doesn't just hurt your life care plan numbers or your lost wages. It hurts your non-economic damages. It hurts your fault, and it hurts your chances at winning. The one statistic that is undefeated in our studies is that if the defense case tests as more credible than the plaintiff case, when we say, how credible was it? If the defense case tests as more credible than the plaintiff case, the plaintiff loses, period. So as plaintiff's attorneys, our job is from voir dire, through statements, through witnesses, through evidence, through economic plans, through closing, to be impeccably credible. And we do that by not reaching, by not exaggerating, by not twisting the words of a witness, by putting in context the things that hurt us, but acknowledging them, by acknowledging shared responsibility cases, by not denying comparative fault when it exists. And this idea that you'll fight anything at any cost and it's a war often costs us our credibility in ways that then damage the whole case.
That's true.
That's awesome and a great place to end. Thank you both so much for taking time to talk with me today. So if people want to reach you guys, I know you're insanely busy as it is, but if they want to do a big study, what's the best way for them to connect with John and Alicia Campbell?
Well, if you go to CampbellLawLLC.com, there's a contact page that emails us directly. You can also email us at alicia@CampbellLawLLC.com or John@CampbellLawLLC.com. Or you can call us on our numbers on our website.
And for those interested in starting to do Fred studies, tell us how that process works and how they get kind of, accepted to start submitting.
Yeah, if you go to www.focuswithfred.com and sign up, and then we'll see you come in, get access, contact you about getting onboarded to learn how the process works, send you all the handouts that we have, and keep in touch with you so that you know how to use Fred and can start using it right away.
I'm just going to say, I know we're wrapping up, but Alicia's like being humble about Fred. She dreamed him up. The fact that on a Friday afternoon, when you're like, I'm kind of tired of doing all the shit I've been doing all week in discovery, you could sit down and just say, all right, I'm going to type out the plaintiff's case, which I know by heart, in 1,500 words. And I'm going to give the defense their fair day. And then I'm going to drop in a couple images and a diagram. And then I'm going to click for 15 minutes on, it's a negligence case, it's a slip and fall, it's a motor vehicle, whatever. I want to ask about these 10 pieces of evidence. And I'd like to know, what else would you like to know? What confused you? And what are the best facts for the plaintiff? And click submit. And then you go home and hang out with your family over the weekend. And on Monday, Tuesday, or Wednesday, you receive a report. As opposed to like, I'm going to hold a focus group on Saturday and buy the Danish and the donuts and show up, and then have the people show up late and then wait and spend my day. It is, for $7,500, it's the best bargain on the planet. And I can say that because I had nothing to do with it. Alicia thought of it, dreamed it up, and built it. But there is a luxury in like having real data and basically doing it from your desk in a few hours.
Love it. And then lastly, April, Jury Ball Madrid, which sadly I'm not going to be able to make. But what's going on there? And are spots still open for people who are interested?
So Jury Ball Madrid is the first Jury Ball conference. We have a stellar lineup. So Alicia and I will be there. Sean Claggett will be there. So all the authors of Jury Ball, but also Nick Rowley's coming to round it out. Valerie Hans from Cornell, Jessica Salerno from Cornell, Nick Schweitzer from Cornell. 3 academics that are at the top of their game about jury behavior. Brent Walker from Dallas, who has more, he and his partner Charles Aldous have more 8-figure verdicts in a span of 3 or 4 years than anybody I know. So it'll be great for learning. But we've structured the day so that you're there from 9 to 2 at a conference. And then after that, you have amazing things you can do in Madrid on your own or with us, like tours of where Real Madrid plays, going to the Prado and other great museums, wonderful Spanish dinners. It's going to be a chance to build community. We have almost 100 lawyers registered now. We have room, if we had to get up to 150. So we think we can take anybody who wants to come, and that's the goal. And our whole goal is, there's a Spanish word, acogedor, which means cozy and warm. And we want the conference, when people leave, to feel like they've experienced a little bit of what we love about Madrid and why we live here. And so we will try to share that with everybody when they're...
Excellent. That sounds awesome. Well, John and Alicia, thanks again so much for your time, and look forward to seeing you and working with you soon.
Awesome.
Thanks so much for having us.
Thank you so much.
That wraps up today's episode of Just Verdicts. A huge thank you to John and Alicia Campbell for sharing their insights on how big data is transforming trial strategy. If you found this conversation valuable, do me a favor. Share this episode with other lawyers who could benefit from it. And if you're enjoying Just Verdicts or my trial nuggets, take a moment to leave a review on your favorite podcast platform for me. Your support helps more trial lawyers discover the show and improve their craft. Thanks for listening, and I'll see you next time.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.